Okay, good afternoon, everyone. It is 3 p.m. Eastern, so we're going to go ahead and get started. My name is Sasha Beatty, and I am Senior Counsel at the Association of Prosecuting Attorneys. APA is a private nonprofit located in Washington, D.C., serving prosecutors as well as their law enforcement and community partners. We thank you for joining this prosecutorial case backlog webinar today. This project is supported by the Stand Together Trust. APA is very appreciative of their financial assistance and commitment to improving the justice system. Points of view or opinions in this presentation are those of the presenter and do not necessarily represent the official position or policies of the Stand Together Trust or the Association of Prosecuting Attorneys. Now, some very brief housekeeping. If you have a question for our presenter today, please use the Q&A widget at the bottom of your screen. We will hold questions until the end of the presentation, at which time our presenter will address them. Now, if you're having any technical difficulties at all today, such as audio or video issues, or you have any other questions, you can pop into the chat box. One of us will be monitoring that and will assist you with any sort of quality issues you may be encountering. This webinar is also eligible for 1 hour of California CLE. Attendees are required to self-report, so reach out to apaadmin@apainc.org if you have any questions about this process. It is my distinct pleasure to welcome the Elmore County Prosecuting Attorney, Shondi Lott, here today. A little bit about Shondi. In 1997, Shondi earned her associate's degree in environmental legal studies, thinking that she was going to work as a paralegal in environmental law at the Idaho National Laboratory. She quickly learned that environmental law wasn't her passion, but law in general still was. She was a paralegal for a solo practitioner for a couple of years, then abandoned legal work to be home more often to take care of her first child, who was quickly followed by 3 little brothers. Once her boys were older, she returned to legal work as the managing paralegal and trial assistant at a busy law firm, while also finishing her BS degree in psychology. She went on to complete law school, and shortly thereafter, she accepted the offer to her first prosecuting attorney position in 2015 while studying for the bar exam. Most of her time since then has been in county prosecution. She is currently the appointed and soon to be elected prosecuting attorney for Elmore County, Idaho. Now, I and the team at APA had the pleasure of working with her and her team over the past year and change and getting to know her and her office in Mountain Home. And I'm grateful that she's taken the time to share with us some of what her office has faced and done to address backlog. So thank you so much, Shondi, for being here, and I will now turn it over to you.
Sasha, thank you for that. And thank you for including Elmore County in this project. It's something that before this opportunity came up, I was already trying to look at ideas, and this gave us a great opportunity to do that in a much more focused way than we would have otherwise. So I really appreciate the opportunity. So thank you for being here, everyone. So Elmore County, I'm going to give you a little bit of some background on the county, talk about demographics. I think that's important for because different demographics, some things will work and some things won't. I'll talk about how we got where we are with our backlog, talk about the justice partners that were included in this project as we have been working on it for the last over a year, our resolutions, and then sort of I'm going to talk about what works and what maybe didn't work and what we're still working on and hoping to do in the future that might be helpful to other offices. So a little about Elmore County, Idaho. So we are in the southwestern portion of the state, just south of Ada County, which is where Boise, Idaho is located. Our population is a little over 30,000 people. Currently in my office, besides me, there are 5 deputy criminal prosecutors, or excuse me, there's spots for 5. There are 4. We have 1 open there. I need 1.5 civil prosecutors. I am down by 1 there. We do have 5 office assistants. We're getting ready to post for the first time an investigator position. And just to help put that into scale, we have two magistrate judges and we have two magistrate judges and one district judge, although we share a district judge with another county. This is the Elmore County Courthouse. Obviously, we have been around for a very long time. I took this photograph myself on May 1st. The building was actually built in 1915 and 1916. One of the issues that did come up was the age of the building, which included not enough space for everything that needs to be happening in that space. We are, I hate to use the term struggling when it comes to growth, but one thing that drives some issues is growth in the county. And there are a couple of very large growth projects that are happening. And one more that may happen that's in the works, which is going to exponentially increase the population of the county. So that's something looking forward that we're trying to start preparing for. As you can see, the differences from early Idaho up through, just about 75 years ago and then up to today. And it's definitely going to keep going higher. So how did the reason we're here, the backlog issue, really come forward? So germs, obviously, COVID absolutely impacted all of Idaho's courts. There were several different problems. One of them was the courthouse shutdowns, of course. The way Idaho handled that was divided by the judicial districts. The Idaho Supreme Court issued administrative rules where if the transmission rates of COVID were above a certain percentage, then the courthouse was shut down for anything other than the absolute essentials. And everything, including our criminal cases, were simply put off, rescheduled. Jury trials were vacated. And we only have one room in the courthouse that is large enough to hold a jury trial, felony or misdemeanors. So you can imagine the way that impacted our case law, or our backlog, and how our cases were taking so much more time to get through. Of course, with people being ill, other times things were vacated. Even when the courthouse was opened back up, things were vacated because one of the attorneys was sick or one of the attorneys had COVID, and we had issues with jurors not wanting to show up and things like that. But most of it, as far as absences went, was just simply attorneys who were not able to be in court because they were too sick. The speedy preliminary hearing rule in Idaho is for preliminary hearings, which is what we do in Elmore County instead of grand jury indictments. Those have a 14-day minimum or maximum if the person is in custody under Idaho code. So, and the Idaho rules. So that was definitely an issue. Defendants did have to either waive their speedy preliminary hearings, or the Idaho Supreme Court simply had an interim rule that changed that. There are things besides COVID, though, that got us here. Some of them were simply opportunities to improve along the way, where people have just continued to maintain the status quo and not really gone out of their way to make a bunch of changes. When you get busy, even trying to be more efficient, obviously the difficulty there can be getting time to make those changes, or at least to look into and try new things. That's one of the reasons that I felt this project was going to be so worthwhile, and it has been. One thing that keeps the wheels from turning as fast as we would like is communication issues. How do the prosecutors and defense work together? What decisions is the court making regarding continuances, whatnot? We're a small county. Turnover on pretty much every side of the die is pretty constant. It's not as bad in my office, but we've had a lot of courthouse turnover and whatnot, and that causes issues that also lead to slowing things down. So we've had to look at being able to advocate for keeping these cases moving as fast as we reasonably can and still do a good job, which sometimes has meant we have to make unpopular decisions or make other changes to our processes that not everybody's always happy with. We looked at a wide range of justice partners, and APA was really helpful in identifying really how broad that net is. And as you can see on here, there's everything from, of course, the obvious, which would be law enforcement, courts, judges, and the 4 different law enforcement entities that we work with were at least excited about this project and pretty communicative. The issue that we did have is we have the primary public defender's office, to my knowledge, did not reach out as far as I know, although I have a good working relationship with that office, and we still have these conversations behind the scenes otherwise. The University of Idaho School of Law is another justice partner that I have involved to help address one of our backlog issues, which has been the fact that we have spent so much time understaffed. And we've been involved with them. I have 2 summer interns who just started yesterday for a 10-week paid summer internship that the Board of County Commissioners funded for me. And that's just one more broad way that we've looked at these different ideas. So you can see there's a long list. I won't go through them on this slide, but this is sort of all of them together, not separated out, of the things that we spent some time on. And as you can see, it goes everything from reaching out to an Air Force base, because there's a large Air Force base in Mountain Home, Idaho, because we interact with them if we've got someone who committed a crime inside the county, but off the base. Sometimes we will relinquish jurisdiction, sometimes not, but we share information to help make the prosecution or a disciplinary action on the Air Force base side work a little bit better together. Of course, there's a lot of rules that sort of get in the way sometimes of sharing information, so we have to do it right, but we try really hard there. We looked at things like our search warrants and subpoena duces tecum processes and how we actually get those from the courts, and streamline sort of times that were a default time. So when something wasn't an emergency that could wait, we had kind of a default time everybody expected to handle it. So those are just a couple of the specifics, but we'll go into those. So we narrowed the focus from that list. This is the same list in a couple of ways. So the ones you see that are in gray are issues that we looked at and did not spend very much time on. So you'll see the first gray one on the left-hand column, attorney assistant assignments. The assistants all work with all of the attorneys in my office. We don't have attorney assistant assignments. We considered very briefly making that change in case it would be more efficient. We decided that there just wasn't a great way to do that due to the fact that our office is small enough that it doesn't give any opportunity to have the assistants doing the types of cases or the work that they're best at. Like I mentioned, Elmore County doesn't use grand juries, hasn't for several years, probably close to a decade, if not a little longer, actually. We looked at potentially reconvening the grand jury process to skip the preliminary hearings. That turned out to be something that most people agreed was probably also not worth the effort right now. The bottom left-hand column, we talked to other prosecutors, including part of this project, about not prosecuting certain crimes where there are certain low-level crimes that we were not going to spend resources on because we were shorthanded, even more so than we are now, significantly more so than now. And that was another thing that not only unpopular, I was personally, for our county, I was personally uncomfortable with that. And so we didn't go far there. Reaching out to the Air Force Base was a quick part of the project. And because we don't have a bunch of day-to-day interactions with them, there wasn't much to do there as far as efficiency. I-Court for prosecutors is, of course, the prosecutor version of the Tyler Technologies I-Court system. It does appear to me to be a really efficient system. I think it would be really helpful and obviously would more seamlessly integrate processes between our office and the court. However, it is cost prohibitive for smaller counties. So flipping to the green ones, proving cases, drug cases without labs. Again, at the preliminary hearing stage, we have worked toward getting judges to move into and actually hold a preliminary hearing and bind a defendant over to district court, even if we don't have the lab report yet, so long as law enforcement can articulate why they know that this is in fact a controlled substance and what controlled substance it is. We have actually had some success there. And so that means that instead of continuing preliminary hearings that were scheduled and forcing either the state to dismiss and refile a case because we don't have those labs in time, or alternatively pushing a defendant into waiving their right to that speedy preliminary hearing, we've been able to not have to do either of those things as much. That's been quite helpful. I've advocated strongly for budget needs to be competitive in recruitment for for our attorney positions. Certainly, we're not anywhere close to where we would like to be, but we're closer to being competitive. And the funding for the interns that I mentioned earlier is getting that relationship going on with more people that now know where Elmore County is. It's not that far out of Boise. And once people have learned that, it's been really helpful. The other recruitment tool is accentuating the non-financial benefits. That was something that was discussed as part of this project on our site visit. The sort of brainstorming how to kind of sell those open positions. And so something I have added to the position postings when I go out to on-campus interviews at the law school is to talk a little bit about the environment. It's a rural county for sure. And it's also, though, I think the fifth or sixth largest by landmass in Idaho, although not in population. And so there is lots and lots of space outdoors to do absolutely anything that people dream of doing outside. And it's all right there close to home. Our screening process, one thing that was pretty severely backlogged in our office was our prosecutor reviews. So of course, some of our cases come in because someone's been arrested or given a citation. But some of the cases in our county, we call them a write and route. So law enforcement writes up a report, forwards the report to my office, requesting a review for whether certain charges are appropriate. And those have been another bottleneck because we've been so busy dealing with the cases that are already active and open and the new ones coming in on people who have already been charged, taking time to sit down and look at some of the cases that just have by nature, these are the cases that have those really detailed things that you need to get into to decide whether you can prove this later on. I apologize, you can hear my dog coming in the room, but I've got some help with that coming real quick. Yes, we love our dogs. So I've also looked, we spent some time working, well, I specifically spent time improving our job descriptions, and our county has engaged in a comp assessment so that we can get outside reports that talk about what these jobs are paying in other areas around Idaho that are either close to ours or similar to ours. That gives us more ammunition when, as we are just going into right now, our budget season, when we're asking for more money so that we can pay enough to incentivize people to drive out there, especially if they don't want to live as rural as we are. And so we're still waiting for that comp assessment to actually come back, but it will be back well ahead of budget time. One thing that I spent some time on, but did not get us very far, is pitching some cases to the AG's office or the U.S. Attorney's office when that's appropriate. I've had conversations with both of them. The responses have been somewhat varied, but mostly they're just not interested in most of our cases, even the ones that have either a large quantity of drugs, or we had a case come in, I'd say 8-9 months ago, that had almost any drug that we ever see in Elmore County, and some of them in larger quantities, some in smaller quantities. So they had the U.S. Attorney's Office had expressed interest in cases like that. And then when they were contacted, they did not have the bandwidth to handle them either. So that hasn't actually helped a ton. We're still keeping those communication lines open, however. So here's where we spent a lot of our time moving things around. So the attorney to judge assignments. My predecessor had sort of every attorney in the office took in, they were the handling attorney assigned to most cases that came into the office during their specific week on call. So when you were on call, the cases that came in were generally going to be assigned to you. Which meant a spread across both of our misdemeanor judges and the district court. And there was a lot of musical chairs going on, which drove me sort of bananas. It cuts down desk time. And frankly, I think it made the work environment more difficult, because there was time where I would have rather have been at my desk, but I was sitting in court, even though I only had one case that I needed to be there for. And there wasn't at that time a big culture of covering things for each other. That's a change I've made. It's taken time because we didn't want to pull people off of cases they were already working on or really had invested time in. So we started doing the assignment thing differently right about the time we got our two newest attorneys, who both were just barred in 2023. So they are each assigned to a misdemeanor judge. But one of them is assigned to one of the misdemeanor judges. The other is assigned to the other misdemeanor judge for their misdemeanor cases and their juvenile caseload. That's made a significant difference. There are weeks when, say, that one judge is not available and has not scheduled much. That attorney has a lot of desk time, so they can catch up on things like writing projects, trial preparation, and they can jump in and help another attorney who doesn't have the desk time that they need for those things. I would say out of attorney judge assignments helped with the musical chairs. The next best thing, I think, was I started having conversations about cases being continued multiple times. So we're not ready for preliminary hearing because we don't have drug labs, or we're not ready for preliminary hearing because the attorney has not had time to get offers out. And the defense attorneys like to see an offer even before that preliminary hearing. They're not entitled to one. They're not entitled to discovery necessarily either. At the same time, our judges are going to give them those continuances when they ask for them. So we have pushed in our office to get our offers out earlier. Even if the offer isn't complete, we can usually give the defense attorney something so that they will either waive that preliminary hearing so we get into district court more quickly, or we have also objected to their request to continue so that the court knows we're serious, we're ready, our witnesses are available, and we want to go. That's been getting us some traction as well and saving a significant amount of time. We're mediating more criminal cases than we ever have. This started during the COVID shutdowns and whatnot, at least to an extent. But really, once we saw jury trials picking back up and the time we spend in court picking back up, the defense attorneys got even more serious about these mediations because it means we're not spending as much time in trial when we can get these things resolved ahead of time. And sometimes a good mediator can do what even really good attorneys making a good faith effort can't do. More intern work and better use of interns and semester in practice. I've been working with the law school, like I've mentioned. We were able to secure our 2 interns for this summer well ahead of time, and it was quite competitive this season. And I already have a really suitable candidate for a semester in practice for the spring. So in January, we'll have an extern semester in practice law student who is in their very last semester of law school. I was able to pitch and develop the position for an investigator in our office. And the idea specific to the size of our office and our needs is someone who can be a good liaison with the sheriff's office or our other law enforcement agencies to make sure that we have all of the information we need, who can go out and do follow-up interviews with witnesses when it's kind of gone past the scope of what law enforcement would normally do, but we really need more information. And that can include victims. The person who is a good candidate for this spot is going to have great people skills, but they are also going to be sworn law enforcement. And I have worked out most of those details with the sheriff's office. I was pleasantly surprised at how receptive they were to the idea. And when I pitched sort of my vision, they got actually excited about it and came in with a couple of sort of additional ideas or little tweaks to what I had envisioned that really kind of made this a much more seamless way to work between my office and the sheriff's office. And so I'm really looking forward to getting that going. That person's going to also help save attorney time. It's going to help save cases that may have fallen through because we haven't had enough contact with witnesses and so forth. The court calendar minding and is another one that again goes back to not having to play musical chairs. If that one judge has court on a particular afternoon, and for some reason there's more than one or more than, especially if there's more than 2 attorneys who have cases happening in that same setting at that same time, I have encouraged, and the attorneys have been really good about handing off things like status conferences or pretrial conferences on cases that are resolved that just need to be set over for a sentencing or a plea change rather than, something really substantive happening that the handling attorney needed to handle. So that's also, again, increasing that desk time, which is putting the attorneys in a position where they are not so busy that the job, they can't actually do the work because they're just sitting in a courtroom all the time. Our juvenile cases used to go straight from, there was, an arraignment, and then they would be scheduled for an evidentiary hearing. We didn't have anything that was a version of a pretrial or a status before that evidentiary hearing, which most prosecutors or anyone who works in a prosecutor's office for very long knows that very first time chances of a set over for some reason are incredibly high. And we have started through cooperating with the court, setting up most of those for a pretrial conference or a status conference before the evidentiary hearing. And that has sorted out the cases that are going to be resolved so that we can focus on the ones that are going to be more time intensive. I have just myself, and the asterisks on here are things that really only took my time. Did not take extensive time from the other attorneys or the assistants in the office. So I also spent time investing my own face-to-face communication time with all of the law enforcement partners. I have sat down with our judges, our probation office. I make sure to talk to defense attorneys and basically all of the justice partners as often as I can, with it reasonably, of course. I try not to bug them, but to make sure that we have those communications going. And I mentioned earlier our court personnel turnover, which has been pretty big. And I work closely with our newer court clerk supervisor. And so she and I will sit down when there's one of those issues that has popped up a couple of times to figure out how we can be more efficient in the way we handle those. We have gone to digital media access and file sharing with defense attorneys as far as our discovery responses go. So instead of burning CDs and DVDs, which is what the assistants were doing just a year ago, and probably unsurprisingly, we don't have the most amazing technology. Again, it comes down to financial resources, and it takes time. It was taking a lot of time to burn those and track them. You never knew whether someone had ever opened them or looked at them. And at least now we are sharing these by digital file. And so at least we know they were received. It can't get lost in the mail or anything like that because we send it to their required e-file address. And that has reduced the number of phone calls the assistants get saying, hey, I didn't get my discovery. Well, we sent it on such and such a date. Defense attorney says, we didn't ever receive it. And that, of course, is a problem. It's only fair that they get everything as quickly as we can give it to them. So we have a better system now of being able to say, yep, it was shared on this day. Do you need another access to the link, rather than re-downloading and spending assistant time to do that, and then attorney time to sign supplemental discovery requests and things like that. I've talked about this school more. Biweekly staffing meetings. Anyone in any supervisory position ever, that people walk in and out of your office, request to sit and meet and talk about things. Well, some of those things, and frankly, a lot of them, are the types of questions that everyone is going to have from time to time. And for those sorts of things, I have started doing biweekly staffing meetings with the attorneys in the office. So we all get in the same room. Sometimes I do it in a very structured manner, so that we have sort of a real agenda that we stick to. And I took notes from Sasha, who introduced us to begin with. And okay, I asked you to talk about this thing for 5 minutes. Thank you. And now it's your turn. And so that we can keep the respect of everyone's time, and so that someone doesn't have the opportunity to get off, on a tangent that is more of a one-on-one conversation, because those have to happen too. But these staffing meetings have been able to give everyone access to the same information, when it's information we know that everyone is going to need, or at least everyone needs to know what someone else is doing here or there, or who is a good resource for, maybe an issue that doesn't pop up as frequently. Changes to the discovery process on our misdemeanor cases has saved some time. When my predecessor was there, a misdemeanor case would come in, the office would immediately send over as discovery whatever we had, which at that point in time was usually a PC affidavit, a complaint, and criminal history information. A couple days later, we'd get reports start to trickling in, and there'd be multiple supplemental discovery responses. So that takes assistant time to prepare them. It takes attorney time to review them. And instead, I set up a 14-day system. And so, because our rule allows 14 days to respond to a discovery request. So, and this is on our misdemeanors because we don't have to worry about preliminary hearings. And so we're still way ahead of the pretrial conference. But we're sending one discovery response right around that 14-day time frame. We are absolutely still sending updated responses and supplemental responses as more information comes into the office. But those have been cut down a fair amount because we're waiting to send that first one until we have more information. Of course, on that same note, if an attorney on a misdemeanor case had contacts our office and says, hey, this person, say, lives out of town, wants to meet with me before they go back home, can you send that discovery over earlier? Could just send us what I have? Our answer is absolutely. We still want to work together that way. And so there's flexibility there. We've had more discussions in the office among the attorneys as far as sort of a starting place for certain types of cases that we see frequently. One of them I call marijuana cases. So there's always, say a little bit of marijuana, which is of course still entirely illegal in Idaho, and some paraphernalia to go along with it. And so we've had those conversations so that all of the attorneys are on the same page with, if it's a first time super low quantity type of a case, here's kind of the going rate. There is also the ability to and the expectation to look at the factors that matter for sentencing and look at those 2 Hill factors and say, okay, so I think this one is more serious than sort of the going rate suggests. This one is less serious than that suggests. And so there's still a lot of autonomy. And we individualize every single case because no 2 cases are exactly alike, but it does save attorney time and it helps newer attorneys get used to sort of the office culture and what we sometimes recall or refer to as the going rate for certain first-time offenses. And that's made some of the training easier, as well as helped get those offers out easier and more quickly, so that when those pretrial conferences happen on the misdemeanors, we're able to already have those offers out and things are resolving instead of being set over while a newer attorney figures out exactly what offer is appropriate. I already mentioned streamlining our processes, getting search warrants signed by the court, subpoenas juices tecum. The same is true for arrest warrants. If we've got a case that we need a warrant for rather than someone can just be cited, if it's a misdemeanor or if it's a felony, but they can't be located right now and we're concerned we need that warrant, we've got quicker ways to make those happen. So this is sort of a recap of what we just talked about. So the attorney judge assignments really have hit home. I have followed up before finishing up my materials for today, asking judges how they feel about it. And I got the feedback that they like it. There's not as much physical motion and moving around in the courthouse or in the courtroom while court's going on. And the other thing the judges like about it is they get to know how that attorney works. The attorney knows how the judge works. And so we all know we can be more efficient in those times when we know what to expect from a judge. We still have to advocate for what we feel is appropriate in every single case. But knowing those expectations and just how the justice partners do those things is helpful for everyone. We are absolutely lower on continuances. So we're getting more things through earlier on in the process than we were before. Our judges have expressed appreciation for that and still continue things over our objections on the regular. And they will still ask us sometimes why we didn't object to a continuance request when we felt it was one of those where it was appropriate. So it's not a perfect system. But we're picking up those files less often rather than repeat, showing up just to sort of have the same result and kicking the can down the road. The mediations that have been successful have been on some of our most complex cases. We have been mediating out a lot of sex crimes. The next tier to just getting into more mediations has been in the sex crime cases, recommending or at least giving the idea out there to the defense attorney that if your client wants to get a psychosexual evaluation, which we do in any felony conviction, whether it's a plea or someone goes to trial on it. If they want to get that ahead of time, so that we all know what that risk level looks like to the community moving forward, and that can help inform what we might, where we might come to in a mediation. And it gives a mediator that has experience. Most of our mediators are senior judges or retired judges. So they can explain to both sides, if this case came to me for sentencing and this is what the PSE looked like, you know, here's some things I would really look at closely. So that's the next tier besides just the more mediations that's been helpful for us. Onboarding initially with interns, new employees was definitely taking me some time. I have spent some time to streamline those processes as well, because of course efficiency comes down to systems on a lot of these things. So I've been paying attention to that as well. I've talked about the calendar and discovery. With regard to the school, and I know it sounds like I do talk about the school connection a lot. It has absolutely paid off, however, already in dividends. There are just so many people that know who we are and where we are that simply didn't before. And I'm getting emails from law school students just out of the blue, even outside of our on-campus interviews. And so that touching base and just having people know where we are has already got us on a track to where I think we're going to have a lot better chance of attracting good applicants and then retaining them because they have the chance to make early connections with my office before they are even hitting their 2L summer and looking for internships. So not everything is all directed externally with justice partners. Some of our other internal processes, I mentioned the biweekly staffing meetings. Outside of that, we also update assistants or anyone else that can benefit from the things that we discuss in those staffing meetings. I cannot stress the improvement in communications enough. And sometimes the communications include boundary setting. So there were, after investigating time to improve communications, we understand each other better, both in the messages that we are sharing back and forth, but also with regard to the boundaries of what we do need to spend a lot of time communicating and discussing versus the things that are superfluous or redundant, and setting expectations from both sides on what that communication looks like. And I've had a few difficult conversations with a couple of our departments inside the county that have really actually turned into a better relationship between us and those departments, which helps get the outcome of the whole project, which is better results in our cases. We want to do justice. We want to do justice quickly when appropriate, which is almost all of the time. And we want to make sure that we get it right. And that communication is absolutely key to making that happen. So again, our speed has been moved up, and it's only going to get better as we are able to recruit and fill those spots that we have open. That's going to be helpful as well. So what's next? Obviously, I'm going to continue down the road of the things that I feel are getting us the most traction. And I'm also going to continue to try new things. I'm going to continue to get feedback from the justice partners, because my perception is not everything. So I'm getting feedback everywhere that I can. There's boundary setting. Again, like I said, the write and route, we also call prosecutor review. those processes and the level of and amount of communication there is something that we continue to work on. The comp assessment going forward with our budget recommendations or requests to our Board of County Commissioners, that's almost ready. We are supposed to be receiving those results within the next 2 weeks so that we can advocate again to increase the retention of the attorneys we already have and hopefully attract a couple more, as well as get the investigator in. And of course, reevaluating the earlier ones that were grayed out or greened out that we haven't spent as much time on. When I have new things pop up, I like to go back and look at those things and say, okay, so that it wasn't a good time to do that then, but is it maybe a better time now? We've had some case law change in our jurisdiction on the way we can get in CARES interviews and our safe and sane evaluations for victims of sexual assault. Those are becoming more difficult to get into evidence. And so because of that, it may be time to reevaluate the grand jury idea. And this is a conversation I had with a judge just last week or so. And so we reevaluate as we go. And of course, we're watching for that growth element because we know it's coming. So things that I have learned. So first, that feedback before a change, that feedback after a change is invaluable. Of course, we can all get, and me specifically, very set in, oh, here's the results the way I see them. And it's just as important. In fact, it's more important to ask everyone else because there's only, I'm only one person. You have to have the real talk with some of the justice partners and ask very specific questions to sort of set up those expectations and get everyone on the same page, even when those are difficult conversations to have. Reflecting on your results, of course. Being open to new ideas, no matter whose idea it is or where that resource comes from. I think being open to them as you make these changes is absolutely invaluable. I definitely learned some lessons in when to pivot. When something's not working, there is a time to sort of reinforce maybe a new system that wasn't being utilized the way you had initially intended it. And then now it works better. So that's happened. And we've had other things that we've looked at that just are not feasible for one reason or another, or that we tried and realized that there are unintended consequences. And or maybe they just did not have the return on our time investment that we were hoping for. And so you dump those and you move on. And maybe you'll again pick them up later if another time is better for them. It's incredibly important to stand up for, our offices, our cases, ourselves. And it's also absolute at the biggest brick on the bottom is standing up for our justice system in general. If we're not doing justice while we're looking at these things that in the grand scheme of criminal law, these things that we've talked about for the last 45 minutes are really pretty ticky-tacky. When you're thinking about someone, losing their liberty or a fine and their property, that justice has to be done to the very best of our ability, no matter what. And at the same, so while you're doing justice, sometimes when someone else is seeking an unjust result, you have to be able to put the time and effort into standing up and saying, that's not the right thing to do here. Some of the changes that I have made since I was appointed to my position a little over a year and a half ago weren't very popular, but the big changes, I had more conversations earlier on before I made them to decide which changes were really worth ruffling the feathers that I knew they were going to ruffle. And so I did a lot of consulting with other people that were going to be affected by them. And when there was, a person who I knew was going to be really unhappy with the change, whether or not that was going to make or break the decision, I would have those conversations in private before changes were announced. And I think that that's really important, to just show respect and care for the people that we work with. I did not chase high risk or high resource ideas first and without a lot of thought. Of course, in county government, we have budgetary constraints that are completely out of our control. And so those bigger things, and for the size of our budget and our office, just the addition of an investigator position when there wasn't one is considered a big change. And so I had to get the backup put in place before I could pitch that. And it was successful. And if you try something and it doesn't go well, just admit it and move on to the next thing once you realize it's really not going to work right now. I mentioned boundaries as far as not letting, one of the things that means to me is not letting other people monopolize too much of your time when it's taking away from more important things. I am one of those people that will take being efficient a little too far and say, this is not an efficient way to have this conversation. We need to do it a different way. Instead of asking someone else who is the other communication partner, what is a better communication strategy for us to work through this type of issue when it comes up? And so instead of just being a jerk and cutting someone off and saying, I don't have time for this right now, send me an email, there are other ways to have those conversations and make those decisions. Well, thank you so much for your time. I am happy to answer any questions that anyone has. And that is my office phone number, and that email does go directly to me. You're absolutely welcome to use it.
Great. Thank you so much, Shandi. At this time, we can open it up to any questions. If folks have any, you can use the Q&A box at the bottom of your screen or the chat box if that is easier for you. And normally, Shandi, I would ask presenters at this time, if there's one thing that folks can take away from this presentation, what would it be? So if there's one thing that you would try to sort of underline or impart to our attendees here today, what would you want folks to take away?
I think that the biggest takeaway from this project for me has been to have a much more open mind than you maybe otherwise would. I definitely walked into my position and into this project with an idea of the thought of, I have all these great ideas, and but I want to hear other people's ideas too. And I have grown a lot by realizing that not all of my ideas are great ideas, even though I've worked here for a relatively long period of time. So the more open-minded you can be to these different people's perspectives, and second guessing yourself more than second guessing other people, has been helpful to me.
Great, thank you. We have some questions here. How did your office personnel react to your changes?
Depends on the change. Lawyer answer, right? It depends. I did a big restructure, for example, of the different duties of the assistants in the office. Similar to the way the attorneys were all assigned to all of the judges' caseloads, and everything from misdemeanors, infractions and misdemeanors and felonies. Getting people in the same seat more often and not trying to be in multiple seats at the same time was something that I extended to a change I made with the assistants, so that the ones who are really good communicators with the public spent more time there, and the ones who are really good at digging into the details for trial preparation, making sure that discovery on, the worst cases where any mistake is, could be fatal to the case and really leave a victim hanging out there and endanger society, that those sorts of projects have gone where someone enjoys spending that sort of time in them. And I got very mixed results. I got thank yous and I got tears initially. Just less than a week ago, one of the assistants who was in tears over some of those changes actually said, "Thank you. I am not overwhelmed anymore, and I really feel like I'm valued for what I can do instead of always feeling bad about what I can't do." So time really did make a big difference in those. The other, so of course you have both of those, but the other thing is sometimes some people have just been purely indifferent, sort of like, all right, whatever floats your boat. What do you want me to do? Kind of looking at their watch, like, are you done telling me about this change? But when that's happened, I've also noticed that those are some of the things that those changes can tend to be undermined a little bit if people aren't taking them seriously. So communicating, is this a policy or is this a suggestion? It became something I got a little more natural at. And I've had better luck with other people following the rules once it was communicated more that this is an expectation rather than an idea that I had. And I haven't had a ton of pushback.
That is so helpful to hear. Thank you, Shandi. One more question before we go. And maybe not naming names, but is there anyone who has been a terrible person to work with? How did you deal with that?
Did you say a terrible person to work with?
Maybe substituting difficult or something along those lines.
Yeah. And of course, those people tend to sort of pop up more during some of those changes. I've had really only one, two, now I'm going to say two or three in the entire group that I've worked with on this project. And the one that I was concerned was going to be the biggest obstacle to getting value out of this project and actually making some lasting changes in our office after including them more and asking their opinion more often. I actually got a partner to help implement these more. And this person is someone is someone who is quite rule oriented and has done a great job of helping me remind others of, hey, and whether it's internal or whether it's instead of inside our office working with one of the partners inside the courthouse, hey, remember when we sat down and talked about this process? That's not what's been happening. So do we need to change that process again, or do we need to go back and have another conversation about how to actually make the new process work? So that person, that I was most worried about, has become really an ally by including them more. And some of the other pushback situations that have come up, I have had to sort of set those bigger boundaries as far as how much time we're going to spend butting heads. And when that happens, you kind of define lanes and define who has the, sort of last say on what's happening on any particular thing. And then you just have to follow through with it and just leave that boundary in place because you're never, ever going to please everybody.
I think that that's a really great answer and something that all of the sites who've participated in this program maybe have learned is you can't necessarily please everybody, but you can bring people into the discussion and take what they have to say into account as you make those changes and as you navigate those fixes. So thank you so much, Shandi. I think those are our questions. So appreciate your time and thank you for sharing your experiences and sort of those valuable lessons learned with us today. For those of you who wish to watch this again or share this with others, this webinar and any sort of corresponding presentation materials will be made available on APA's website, our YouTube channel, our membership database within 5 business days. And just once again, Shandi, thank you so much. That was a tremendous presentation and your insights are so valued. So thank you.
Thank you for including me and bringing us into the project. I appreciate it.
All right, that concludes our webinar today. Thank you so much, everyone.
Thank you, Sasha.